We appreciate it. Next, we'll hear from Ms. Maccabee from WaterLegacy. If you could come down, thank you. Ms. Maccabee, I have you down for 10 minutes. Welcome, good to see you again, and if you could identify yourself for the record and who you represent. Thank you.
Thank you, Mr. Chair and committee members. My name is Paula Maccabee, and I live at 1961 Selby Avenue in St. Paul. I serve as the Advocacy Director and Counsel for WaterLegacy, which is a nonprofit group formed to protect Minnesota's water resources and the communities that rely on them. Our 10,000 members include people who hunt, fish, and gather wild rice, as well as teachers, chemists, and biologists. They have identified wild rice as an indicator species for Arrowhead regional ecosystems and have made the preservation of natural wild rice a high priority. So as a result, WaterLegacy has been active in evaluating and preserving the wild rice sulfate standard since at least 2009. We've reviewed thousands of pages of federal and state documents dating back to 1973 when Minnesota's wild rice sulfate standard was adopted. We were involved in the 2011 session when this legislature appropriated over $1 million to study the impacts of sulfate on wild rice. We've served actively on the advisory committee that was created by this legislature, and we've participated in every step of the scientific peer review process, going to every meeting and presenting information and watching the scientists at their work. In addition, when the Chamber of Commerce sued the state in 2011 to prevent enforcement of the wild rice sulfate standard, arguing many of the things they're arguing today, WaterLegacy intervened in the court case. The Chamber of Commerce claims were defeated and dismissed both in Minnesota District Court and at the Minnesota Court of Appeals. WaterLegacy is here today to speak against the adoption of House File 1000 on two separate grounds. First, the scientific evidence gathered as a result of taxpayer-funded research demonstrates clearly that interference with enforcement of the existing Minnesota wild rice sulfate standard would be unreasonable and unscientific. Second, legislation that would prevent the Minnesota Pollution Control Agency, or MPCA, from fulfilling its obligations to control sulfate pollution and list wild rice impaired waters would conflict with the Clean Water Act, which is governing federal law. As the U.S. Environmental Protection Agency, the EPA, advised in 2011, failure of our state of Minnesota to comply with the Clean Water Act and enforce the wild rice sulfate standard could result in Minnesota's loss of state authority to control state water pollution. First, Minnesota's existing wild rice sulfate standard is reasonable and it should be enforced. Since 2011, the MPCA hired the best scientists from the University of Minnesota and engaged in the most comprehensive study of wild rice sulfate anywhere in the world. As a result of this research, the MPCA concluded in February 2014, sulfate is not directly toxic to wild rice. However, sulfate in the surface water can be converted by bacteria to sulfide in the rooting zone of wild rice. Next, sulfide is toxic to wild rice. And the MPCA continued, and this document was never released to the public, but we got it. It's an official document under the Data Practices Act. People in the public are entitled to get these documents. The MPCA continued, the 10 milligrams per liter sulfate standard is needed and reasonable to protect wild rice production from sulfate-driven sulfide toxicity. And finally, the 10 milligram per liter wild rice sulfate standard should continue to apply to both lakes and streams. Then the Pollution Control Agency, to add another level of scientific protection from any pressure to deregulate pollution, had a panel of 7 international scientists review the wild rice sulfate research in detail. And these scientists issued their final report just in September of 2014, not that long ago. Although the scientists asked for more statistics to tease out the sulfate interactions in the environment with phosphorus and iron, they told the PCA also that sulfide might be even more toxic than the agency had thought. And finally, the peer review panel found that Minnesota's research and regulation limiting sulfate to protect wild rice was scientifically valid. And the panel explained that just as our laws limit mercury, even though the toxic chemical is methylmercury, that it is legitimate to regulate sulfate. And this is a quote from their report: sulfide is harmful, but sulfate is what has to be regulated.
Ms. Maccabee, excuse me, I forgot to note, members, you have the handout that Ms. Maccabee is following on. She's now at the top of page 3. Continue.
Thank you, sir. Second, the Minnesota Pollution Control Agency is obligated under federal law to enforce the existing wild rice sulfate standard and to list wild rice waters that are impaired by sulfate pollution. And you will find, Mr. Chair and committee members, in your handouts, documents and excerpts of documents that have to do with some of these legal issues. I'm going to summarize them briefly. First, as committee members might remember from 2011, the EPA has already explained to Minnesota that state law may not interfere with enforcement of federally approved water quality-based effluent limitations and permits, including the wild rice sulfate standard. The wild rice sulfate standard was adopted in 1973 under the authority of the Clean Water Act. It was reviewed and it was approved. So if you can recall, and I have a copy in there of the EPA's May 13th, 2011 letter, and I'm just reading it without all the citations. A state with a federally authorized NPDES program is required to issue permits that ensure the protection of federally approved water quality standards. Where a state proposes to issue a permit that fails to apply or ensure compliance with any applicable requirement, including water quality-based effluent requirements, EPA has the authority to review and to object to such permit issuance pursuant to its authority. So if the state were to have permits that did not enforce the wild rice sulfate standard, the federal government has the power basically to take over the permitting function. And the question that is really before us in this bill, whether the wild rice sulfate standard must be enforced in wild rice waters that are not listed by name, has been addressed both by the EPA and by Minnesota District Court. In your packets, you can see from the environmental review documents for the KETAC and the Polymet project that the EPA concluded enforcement of the 10 milligrams per liter wild rice sulfate standard was mandatory. It's not discretionary. And the EPA also said that the standard must be enforced in waters such as Swan Lake, Swan River, Hay Creek, Hay Lake, and the Partridge River, where site-specific data showed that wild rice was present. Judge Marinan in the District Court in Minnesota concluded in dismissing the Chamber of Commerce lawsuit, and these are her words, neither the Constitution nor Minnesota or federal statutes require a state to list expressly every surface water to which a water quality standard applies. Such a requirement would be particularly absurd in a state such as Minnesota. And in another conclusion of law, on the contrary, the Federal Clean Water Act allows for application of water quality standards to water bodies that are implicated without being expressly listed on an individual basis. And just as enforcing water quality standards, including the wild rice sulfate standard, is mandatory, not discretionary, states are also required, and this is under Section 303D of the Clean Water Act, to list impaired waters. The Clean Water Act requires all states to submit to EPA every 2 years a list of impaired waters and then to set priorities for plans to clean up those waters. And that's that TMDL thing that you've probably discussed in other hearings. Minnesota has an obligation, which has been affirmed by EPA, to release a list of wild rice impaired waters, and the deadline for that release was actually 2014. So provisions of House File 1000 stating that the Pollution Control Agency should not apply the wild rice water quality standard or list wild rice impaired waters until the Pollution Control Agency adopts rule changes, that is inconsistent with Federal Clean Water Act requirements. And state failure to comply with the Federal Clean Water Act matters. In 2011, the EPA included in its letter to this legislature on May 13th the following advice. Should EPA determine that a state is not administering its federally approved NPDES program in accordance with the requirements of the Clean Water Act, EPA has the authority to require the state to take corrective action and, if necessary, to withdraw authorization of the program. Now, federal regulations copied on the last page of our committee handout provide that the EPA may withdraw state authority to regulate water quality when a state program no longer complies with federal clean water law. Among the circumstances that demonstrate noncompliance are failure to issue permits, issuing permits that don't protect beneficial uses, failure to act on permit violations, and this one is a quote, action by a state legislature or court striking down or limiting state authorities. Water Legacy agrees with many of the people who've testified today that it would be better for all of us if MPCA could proceed more quickly to release its proposals regarding the wild rice rule. However, we believe that the proposed HF 1000 legislation is part of the problem, not part of the solution. Every time political pressure is proposed to serve the interests of the mining industry and other industrial dischargers, we believe Minnesota slips farther away from science and farther away from the Clean Water Act requirements to control sulfate and other pollution in order to protect wild rice and also to protect mammals, wildlife, and other uses of clean water. At some point, we are afraid Minnesota's legitimacy in serving as a regulator of water pollution discharged by the mining industry will reach the point where our state's authority can no longer be defended or sustained. I'd be pleased to answer any questions by the committee.
Thank you, Ms. Maccabee. We'll continue on with the rest of the testimony and save the questions for later. And thank you for keeping close to your time limit. I appreciate that. Next, we have